So how do we feel about the Supreme Court today? Is it doing its job the right way? We see there, of course, former Solicitor General Elena Kagan, and now Justice of the Supreme Court, and the first female Justice of the Supreme Court, Sandra Day O'Connor. How does a case get to the Supreme Court? Over 100 million cases initially filed in U.S. state and federal trial courts. And we finally get to the Supreme Court, which here in this example we see released 81 opinions in its one-year term. You also can see here up in the middle, original jurisdiction cases, 5 cases in that one-year period. So of the cases filed at the Supreme Court, the Supreme Court hears approximately 1% of those cases. So there's a lot of court cases that are filed. You know, you always hear people say, well, we'll take them to court. We'll take them all the way to the Supreme Court if we have to. Well, that's all fine and good. However, with the rule of 4, the court itself has to decide whether or not to accept the case. And if it doesn't grant certiorari or grant a writ of certiorari, your case don't get heard. Now, is that the right way? Should the Supreme Court issue writs of certiorari to hear every case? Should cert be granted, certiorari be granted in every case? Should the rule of 4 be the way they do it? You know, there are 9 justices. Here's a good example of how the majority doesn't rule. It's the minority that's protected. The minority gets to rule in this case at the Supreme Court. At least 4 justices have to sign on to a writ of certiorari in order to hear the case. Well, with hearing 1% of the cases filed, maybe that's too high of a bar to get over. And a little talked about fact is that there's an initial filtration process that happens with the clerks, the people who clerk for the Supreme Court Associate Justices. These folks are really a good place to look at because they are acting as a gatekeeper for the cases that come to the court. These are not pencil and paper pushers. These are highly acclaimed lawyers, smart people, well-trained, Ivy League a lot of times, people who in many cases go on later to be Supreme Court justices. So the clerks are something important to take a look at the Supreme Court. So how does the case survive the process? Well, the federal government, with, of course, the Solicitor General, you know about the Attorney General as the chief law enforcement officer and chief lawyer for the United States. Well, it's the Solicitor General who is the chief attorney who argues cases before the Supreme Court. So when the federal government has standing in a case, that is, what it does is directly involved in the case, then the Solicitor General will usually be the person who is representing the United States government. Now, if you're someone who believes in one side or the other of a case, but you don't have standing, you can, of course, as we know, file an amicus curiae brief, a friend of the court. Sometimes it's the cases that get heard where there is a conflict among the different courts of appeals. So different courts of appeals see it differently, and the Supreme Court says, you know what, in order for us to determine the law of the land, we're going to have to take this case. So those are likely cases that get to the Supreme Court and are accepted by the rule of 4. When there are large interest groups participating, we sometimes find that those are cases where the Supreme Court feels like it needs to step in. And while the Supreme Court is supposed to be neutral and interpret the law, of course the court is influenced by public opinion, is influenced by the news and the current events, and of course influenced by the new arrivals at the court based on who gets elected president, who gets appointed, and who gets approved by the Senate. So all of these things can change how the court interprets the law. once accepted, we have, of course, the process where oral arguments are heard. Amicus briefs are submitted beforehand. There's a conference between the justices. Initially, they talk about where they feel like they are in chambers, in closed session. They talk about where they are, and those things can change. And they vote, and those things can change. And then, once they make some final decisions, who's going to write the majority opinion is assigned, and that person writes and distributes his or her opinion in the case. And then those people in the majority can either sign on to the majority opinion, or as we know, they can write a concurring opinion, meaning I agree, but for different reasons, or they can write a dissenting opinion or just vote against. And while the dissenting opinions have no legal bearing, sometimes they do come back years later as the basis for overturning a decision of the court. Just a quick explanation, again, of writs of certiorari. It requires the agreement of 4 justices to hear the case. It involves some significant federal or constitutional questions that need to be resolved, and it involves conflicting decisions by circuit courts. That's usually why cases get accepted by the Supreme Court. What does it mean to have standing? There must be a real controversy between real adversaries in order for someone to have standing. There must be personal harm that's demonstrated, meaning this affects me personally, not just, well, I really think this should happen, or I really think this should be the result. There has to be a personal harm that's demonstrated. So being a taxpayer does not ordinarily constitute entitlement to challenge the federal government's actions, unless, of course, First Amendment's involved. What does amicus curiae literally mean? Too easy? 3, 2, 1.